We're going to shift now to the second topic in freedom of expression. In the first lecture, we left off with speech. Now we're going to be talking about the press, which is, of course, we're still talking about speech, but this one specifically in terms of the media, and we've already mentioned the media in terms of things like commercial speech, things that are broadcast, but here the focus is going to be explicitly on the news media, and lots of it will be about written media, so the traditional press. And the place to start is with the topic of prior restraint. And the press is protected from prior restraint. Now, what that means, and that is underlined because it is an important term, prior restraint means censoring something before publication. That's what makes it, the fact that it's done in advance is what makes it prior. The restraint is a restraint on what can be published. And this protection is something that comes out of the decision of Neer versus Minnesota in 1931. And this is an important case. Notice it is not an AP required case, but it is an important case because it provides an excellent example of incorporation via the 14th Amendment. So a Bill of Rights protection that is incorporated into the state level of government, or the protection against prior restraint, protection of freedom of the press, is incorporated to individuals against their state governments. There's some different ways to think about incorporation. I hope to help it make it easier to remember. What this case also says, in addition to being an example of an incorporation, is that there can be no prior restraint unless the speech that is going to be presented or printed is of an unprotected nature. So, for example, an article that was giving away military secrets during wartime. So perhaps journalists were aware of a movement of troops in a battle or movement for an upcoming battle, and they were to publish that. That would give away important military secrets that could cause losses and get people killed. So that would not be protected. And in general, what we see is there is more latitude for restricting speech during wartime. That's just something to keep in mind. We also need to understand that protections vary much by the type of media that is being regulated. Broadcast and TV, radio are less protected because of the nature of how their particular forms of media operate. Both of them require use of public airwaves. The companies, these are kind of treated like a common resource in a sense. They are available, but one person or one company's use of those resources limits the availability to others. If KQ2 is using Channel 2, and they're broadcasting on that part of the frequency spectrum, nobody else can within the radius of their broadcast area. The same goes for radio stations. So for that reason, those companies have to apply for a license with the FCC. They have to pay licensing fees. And because they are seen as using this common resource, it is more of a privilege than a right. And so what they put out over those airwaves is less protected than, say, what is printed in a newspaper or a news website online. And this limit on protection was made clear in Red Line Broadcasting versus FCC in 1969, which is tied to the Fairness Doctrine, which the Fairness Doctrine actually precedes Red Line Broadcasting Company versus FCC. This case was kind of a test of that. And the Fairness Doctrine we get it in 1949, and the idea here is that companies that hold a broadcast license must cover controversial issues, and they must cover those issues such that they are kind of fairly giving time and weight to each side in a debate or multiple sides in a debate. And the print media is not bound by this. That was established by Miami Herald Publishing versus Tornillo in 1974. Sorry, just noticed that there was an L missing from Tornillo. And the reason that print media are not bound by this is, again, because they do not require the use of public airwaves. I should also point out that the fairness doctrine has been abandoned for quite some time. I believe it went out in the late 1980s. Not as a result of a court case, but the FCC kind of abolished that doctrine from its regulations. It's just a little bit of trivia for you. The main upshot here to understand from this section is the varying levels of protection, because that is important to understand, especially given the current debates about what license holders must do in terms of who is on the air on their stations, Jimmy Kimmel, how they are covering things like the Iran war, for example. Here we're going to go more generally to talk about limits on freedom of the press. For one thing, libel is not protected. Remember, libel is the written form of defamation. Here, understand that the standard for libel differs for different people. If you are, like me, just a run-of-the-mill average Joe, if somebody writes something that is false and defamatory against me, the bar is lower for me to prove that I have been damaged by this defamation. For public figures, movie stars, sports heroes, politicians, for those public figures, the bar for them to sue and win a suit for libel is higher. And of course, this is all done in civil court. They must prove malicious intent on the part of the publisher of that speech. And this comes to us from New York Times versus Sullivan in 1964. Obscenity is also not protected. I told you we would come back to the topic of obscenity. The case that excludes obscenity for protection more definitively, Roth versus United States in 1957. But that still leaves the question of what is obscenity, and that is kind of the forever question, right? What counts as obscenity? Miller versus California weighed in on this in 1973. The Supreme Court ruled that some of this would vary from community to community in terms of what standards they had for what constituted proper versus obscene, or appropriate versus obscene. It remains an unsettled question. I often think about protections for obscenity when I look at all of the bumper stickers and window decals on cars and trucks today, compared to what they were like when I was a kid. And for one thing, you just didn't see as many of them, and they were mostly very, very tame compared to what is on there today, out there for my kids to see from the back seat of the car. There are also limits on criminal proceedings. The press is allowed to report on trials and criminal proceedings, even if this conflicts with the societal and constitutional objective of the right to a fair trial. In pretrial proceedings, news outlets can report on the defendant. They can report on likely evidence, all kinds of things that might prejudge society, the community one way or the other, and that can make it difficult to do things like find jurors. It can also create an environment outside the courtroom that is very different from kind of the cool, objective, evidence-based events inside the courtroom. But again, the trials in this country are public. That is also a constitutional right, to have a public trial. and the news media can report on those public events. But, and this is where the limits kick in, journalists can be legally required to provide testimony in court about their confidential sources. Journalists do not have the equivalent of attorney-client privilege. Attorney-client privilege is ironclad. What you say to your attorney cannot say to anyone else, communicate to anyone else without your permission. But journalists can have confidential sources. If that journalist is subpoenaed to testify in court, they may have to testify about those confidential sources. And that was established more than 50 years ago in Brandsburg versus Hayes. Also, media outlets that may have sensitive information about their sources and other things can be searched with a warrant, just like a person's home can be searched with a warrant. And that was established nearly 50 years ago in Zurcher versus Stanford. So media outlets can, especially if we're talking about newspapers, they have wide latitude, tremendous latitude to print what they want to under First Amendment protections, but the information they possess, the things they possess, are not inviolate. Again, they can be searched with a warrant. We're going to switch now to freedom of assembly. And this, of course, is our right to assemble peaceably. And we can protest, we can demonstrate. And in terms of the protections, in terms of content, there are essentially no limits on the content of groups' messages. This was established in NAACP, National Association for the Advancement of Colored People, versus Alabama in 1958. Groups of all kinds can come together around essentially any interest. And that includes anti-racist groups and racist groups. This is, if you're wondering if this is some kind of AI-generated thing, no, this is from the 1920s. It is a Ku Klux Klan parade out in the open with spectators. I notice those spectators don't seem to be a counter-protest, right, in front of the Capitol building. However, your right to assemble is subject to what are referred to as time, place, and manner restrictions. And this applies to the incident in this picture here, Ward versus Rock against racism. You cannot have a protest whenever you want to, wherever you want to. And in the case of this event, you may not be able to use your own audio equipment to be as loud as you want to. So if it seems anathema to you, the idea that protesters would have to get a permit to protest, those restrictions are constitutional because of decisions like this. Your group can have the content at once, but where, how, and when they are able to share that message is limited and limitable. In this case, it was volume control. There are limits on these restrictions. So the restrictions have to be content neutral, again, because there are essentially no limits on the content of a group's message. So you can't have something that restricts the volume, but only for far-right groups. It has to be content neutral. It has to be narrowly tailored, meaning it has to be a restriction that is as narrow as possible to achieve the desired outcome, such as not disturbing people with loud sounds. And it has to allow groups alternatives for protest. So the restrictions can't be something that would make it impossible for that group to share its message. Now, for something not completely different, but rather different, the right to bear arms. This is protected, of course, by the Second Amendment, and I'm sharing with you some of the bad memes and jokes that I have had to suffer through in my decades on this earth, so you get to suffer through them too. This amendment, of course, is subject to a lot of debate and controversy. Until relatively recently, and I do say relatively recently, certainly within my memory, states had a lot of authority to regulate firearms, possession, sales. When I was a little older than most of you watching this are now, you had to file a permit before you could buy a handgun. You're supposed to provide your reasons. You had to provide information about yourself. You had to submit that to the sheriff for approval to buy a handgun. And if I remember right, once you got that approval, it was temporary. You had to use it within a certain period of time, or you had to reapply for a permit to purchase a handgun. And this was possible because the Second Amendment was not incorporated. Remember, incorporated means that the courts have ruled that a Bill of Rights protection also applies at the state level and not just the federal level. In the 21st century, there have been important changes. First, there was District of Columbia versus Heller in 2008, which established the judicial precedent that individuals have a right to possess firearms even if they are not in a militia. Because remember, the Second Amendment talks about the necessity of a militia, and because of the necessity of a militia, the right of the people to bear arms shall not be infringed. This said that that right is not attached to service in a militia. And I put state in parentheses there because state militias, those were the kinds of militias that existed at the time of the Constitution's writing. And they were kind of volunteer, but state organized and state led militia groups. What we have now in their place are National Guard units. So when you hear about militias today, typically you are talking about people who are just joining together purely voluntarily and training for military action, who are also often very much anti-government, not the same kind of militia. So the Supreme Court said is even if you're not in one of these official paramilitary or military bodies, you have your own individual right to possess firearms. But that did not incorporate because the District of Columbia, of course, is not a state, and it is administered by the federal government. Incorporation came in McDonald versus Chicago in 2010. This incorporates that same interpretation of the Second Amendment for state and local governments. And here, specifically, it is not purely trivial that we mention state and local governments because a lot of gun control activity or policies are enacted by big cities like Chicago or New York City. And so those two cases have led to dramatic changes, but the policy debate is far from settled. There's lots of room left for the Supreme Court to kind of fine-tune the limits on individual weapons possession. And so there will be more to come on this subject. It's time for an attendance check. Let's see, our terms for this attendance check will be archipelago. Don't worry too much about that one. I think you'll be able to figure out the spelling of that, or at least enough to identify it in the Ed puzzle. Poodle and swordfish. All right, back to the lecture. Our last topic in this particular lecture, we're going to start looking at defendants' rights, and which we also refer to as rights of the accused. And this is also subject to quite a bit of controversy. And it has been importantly affected by technology, surveillance technology, forensic technology, such as DNA evidence. So I just want you to kind of understand that up front. We will try and take things based on their historical development and as current as we can get with interpretations today. We're going to start with the Fourth Amendment, which of course protects us against unreasonable searches and seizures. And this means that private property requires a search warrant. Now, be careful. If you were pulled over on the street and the police ask to search your vehicle, you have far less leeway to refuse to let them search your vehicle. I'm not giving you legal advice. I can't do that. But because you are operating your vehicle, which you may well own, but you are operating that vehicle on public roads, there is a presumption that you have sacrificed some of your right to privacy by operating your motor vehicle on public roads. There is also a carve out here. If law enforcement fear reasonably that evidence will be destroyed, removed from a site unless it is searched at that time, they may be able to search without a warrant, and that search will be upheld as constitutional and lawful. Yeah, but in general, requires a search warrant. Attached to this is the exclusionary rule, which was incorporated from the federal level, but also to include state level in Mapp versus Ohio in 1961. And the exclusionary rule is simply this: evidence that is obtained through an illegal, unconstitutional search may not be used as evidence in court against a defendant. This was weakened somewhat by the decision in the 2009 case, Herring versus United States, which says that criminal courts should account for the possibility of what are referred to as good faith searches. So the law enforcement undertaking the search believed that they had the proper authority to do this, but they were mistaken. And I believe the case about this, police were operating with a warrant for a man. It turned out that warrant, I can't remember if it had been expired or rescinded, but as far as they knew, it was a valid warrant. They pulled the guy over, they searched, they found evidence of criminal activity, and that man was prosecuted. And of course, the issue is whether or not that evidence should have been excluded, because the search was conducted based on, it was an arrest warrant, not a search warrant, I believe, but it was conducted with an improper warrant. And what the Supreme Court said was these kind of instances should be rare. It shouldn't cause a threat of the Fourth Amendment being generally disregarded, and we have to allow for the possibility in kind of today's computer-driven world where lots of things can change and mistakes can be made for technical reasons. And we have to allow for the possibility that police will sometimes undertake a search in good faith, but in error. Right? And that evidence should not necessarily be excluded for that reason. So the courts need to take account of that and weigh up the situation before simply excluding the evidence. So that complicates things for the exclusionary rule. In regard to the Fourth Amendment, of course, we also need to talk about the Patriot Act and the Foreign Intelligence Surveillance Act, both from the early 21st century, or early this century. We're still living in it. And to keep things simple, the upshot of both of these is that there is an increase of government surveillance of suspects, or in many cases, might be thinking about the population at large without warrants. Yeah, but I mean, the real concern for most people focused on this is warrantless surveillance of people who are actually suspected. I don't want to cause people to have undue paranoia about their privacy. You guys don't have any privacy anyway. If you're hanging out on social media, you're being spied upon, and you are giving up your information about yourself enthusiastically in most cases. But in terms of the Fourth Amendment, there are concerns that this warrantless surveillance could be in tension with the founders' goals for the Fourth Amendment. Moving on now to the Fifth Amendment. And I do want you to understand at the outset that the Fifth Amendment's protections are not purely about rights of the accused. There is a bit in there that is relevant to something called eminent domain, where the government can take your property for things like public projects, but also perhaps private projects that might have especially a revenue benefit or an economic benefit for the community and the government. We, of course, here are focused on rights of the accused. And for the rights of accused, there's a lot of protection that is spelled out in the Fifth Amendment. And so first, and this is at least relatively well known, especially among high school government students, you cannot lose your life, liberty, or property to the government without due process. You can't be executed, you can't be imprisoned, and perhaps can't be fined without due process. One of the lesser known protections, especially until recently, is that you cannot be prosecuted, and so formally charged, brought to trial for serious federal crimes, sometimes referred to as non-petty crimes, without grand jury indictment. For most of my life, grand juries have only periodically been in the news, and they've typically not really been explained to the public, not because anybody's trying to keep them secret, but a lot of the time they have not been really key parts of the story for those who were concerned and covered these issues. More recently, grand juries have been in the news, particularly for cases like this, where federal grand juries have declined indictments, high-profile indictments. This being taken from the case of 6 Democrat lawmakers who recorded a video that was widely distributed, reminding troops that they did not have to follow illegal orders and that they should not follow illegal orders. President Trump was very angry about this, as you can see in the headline. Federal prosecutors took these cases to a grand jury seeking an indictment, and the grand jury refused to offer that indictment, and that was the end of the prosecutorial process for those cases. So the grand jury can play an important role of screening out cases before a person is actually charged and prosecuted in court for a criminal an allegation of criminal activity. Perhaps a better known protection, double jeopardy. You cannot be tried twice for the same crime. Self-incrimination. This is perhaps the best known protection in the Fifth Amendment. It is the requirement that you cannot be required to essentially testify against yourself in court or say things that would incriminate you even before a court case. And that is spelled out clearly in the Supreme Court's decision in Miranda versus Arizona. Mr. Miranda was arrested. He was accused of serious crimes, and he was subjected to various forms of interrogation that were used against him in his trial, and he was convicted. His lawyers argued that the police had an obligation to inform Mr. Miranda that he had the right not to say things to the police in interrogation to avoid incriminating himself. And as part of that decision, we have today what is called the Miranda warning. Law enforcement are required to inform you that you have the right not to talk to them and that anything you do say when talking to them might be, or can and will, in this case, and it's stated very strongly, be used against you in a trial. So what we often see is, for one, this, especially in TV dramas where someone is arrested, but you will also see this in lots of situations. It could be in congressional testimony even, certainly in court cases. Individuals will plead the Fifth or exercise their Fifth Amendment right to not say things because those things they might say would incriminate them. And so again, that's probably the best known of the Fifth Amendment protections. Sixth Amendment protections, as you might guess, there's more to the Miranda warning. A lot of that comes in from the Sixth Amendment. Sixth Amendment tells us that you have the right to an attorney. This, of course, applied to federal cases. It was incorporated to the state level in the case of Gideon versus Wainwright, 1963. This is, for those of you who are preparing for the AP exam, an AP required case that will get some more attention later. Going along with this is, so you see that number 3, you have the right to talk to a lawyer and have them present with you, while you are being questioned. And if you cannot afford a lawyer, one will be appointed to represent you before any questioning. That is, of course, this is for the interrogation, right, your interactions with law enforcement. It's not limited to that. You have a right to an attorney to represent you in court. If you are unable to afford an attorney, the government will provide one to represent you in your case. These are the public defenders that are for people accused of crimes who lack their own financial means. They are kind of unsung heroes, especially in states like Missouri where public defenders have historically been under-resourced, that there's been some move to give them more support, more resources. But that's what public defenders do. They provide those legal services to people who cannot afford them. And this is one of our examples of a positive right that is present in the Bill of Rights. It's there to make sure that your civil liberties are actually available to you, even if you don't have money. This also sounds like a good time for an attention check. Let's see, our terms for this attention check. Let's do some phonetic alphabet stuff. Alpha, Bravo, Charlie, Delta. Alpha, Bravo, Charlie, Delta. Those, pay attention this time. You've got 4 terms for your attention check. Now let's move on. Another Sixth Amendment protection is that you have the right to a trial by jury of 12 jurors. This is, I put this in italics, this is only for federal cases. States can have their own standards. I also want you to understand that you have the right to a trial by jury in federal cases. You do not have to have a trial by jury. Defendants can waive their right to a jury trial and can, and sometimes want to, request a bench trial, which means the judge will decide the verdict in the case. For serious charges, or what I previously described as non-petty charges, one of your Sixth Amendment protections is also that the jury must have unanimous agreement before you can be convicted. If you do not have unanimous agreement, you have what's called a hung jury, and you cannot be convicted by a hung jury. This was incorporated to the state level recently, Ramos versus Louisiana in 2020. Prior to this, states could have different standards, and a jury might not have to unanimously agree in order for a defendant to be convicted. One thing that, if you were to take my law and citizen class, which fortunately I have not had the opportunity to teach this year, may not get to for the foreseeable future, nearly all cases, estimates from the low end range at 90% up to, I think it's 97, 98% of cases do not go to trial. They are settled by plea bargaining, and there's a lot of discussion as to whether or not that's a good thing. Here, we don't have time to get into that, and this is not my law and citizen class, but I do want you to be aware that a vanishingly small percentage of federal criminal cases go to trial. They are instead settled by plea bargaining beforehand.